Welcome to the second of 5 installments in the webinar series titled Enhancing the Value of Growing Private Equity Platform Companies via Proactive Compliance Initiatives. Today's program will address and provide guidance on add-on diligence strategy in healthcare. Before we begin the presentation, please note that today's webinar is being recorded and participant phone lines will be placed on mute throughout the program. You're welcome to submit questions directly to the presenters during and after the webinar. Their contact information will be displayed again at the end of the presentation. In 2 to 3 business days, Epstein Becker Green will email registrants a link to access a recording of today's program and PowerPoint materials. Joining us are 3 Epstein Becker Green attorneys. Josh Freemire is a member of the firm in the healthcare and life sciences practice. His experience includes working with private equity companies and other healthcare investors and their portfolio companies on a broad spectrum of health regulatory concerns, including fraud and abuse, privacy law, licensing, reimbursement, multi-jurisdictional practice, and entity structuring, compliance, and disclosures. Anjana Patel is also a member of the firm in the healthcare and life sciences practice. She has represented a diverse group of healthcare providers in matters involving mergers, acquisitions, consolidations, affiliations, joint ventures, physician alignment transactions, MSOs, ACOs, IPAs, clinical integration networks, population health and direct contracting, and other strategic transactions designed to better position providers in the changing healthcare marketplace. David Weiss is a member of the firm in the corporate services and healthcare and life sciences practices. He has extensive experience representing emerging and established companies on corporate and securities matters, including mergers and acquisitions, public and private securities offerings, securities registration, and general corporate matters. He also assists public companies with their reporting obligations to the U.S. Securities and Exchange Commission and related compliance matters under the Securities Exchange Act of 1934 and the Securities Act of 1933. At this time, I'd like to turn the presentation over to Josh.
Good afternoon, everybody. We will be talking through about 5 subject matters today, 5 different key areas. Kicking off with just a quick discussion about what are the differences between platform and add-on transactions. What do we talk about when we use those different terms? Why do those differences matter in terms of forming a strategy for due diligence and for transaction structure? Second, we'll look at health regulatory diligence. In my work with platform companies, I frequently hear folks not really looking at healthcare diligence for smaller deals. But for add-ons, including especially healthcare add-ons, small deals can have big consequences. So appropriate pricing, appropriate risk assessment, and appropriate transaction structuring frequently means doing the actual diligence and really looking into the details of the company. We'll talk about key areas of focus for that kind of diligence. What are the must-haves in terms of right-sizing your diligence? Where do you need to focus? And what are the key areas in terms of add-on liability, both in terms of ongoing company value and ongoing company liability? We'll talk about the key ways to right-size diligence. So how do you ensure effectively that your efficient diligence isn't less effective diligence? And finally, we'll talk a little bit about addressing identified risks. How does the calculus of the options change when we're talking about add-ons versus platforms? So frequently when we talk about regulatory diligence for add-on companies, we see our clients want to move past it and go quickly to the next level, just get the transaction completed. So it's important to talk a little bit about why health regulatory diligence matters here and what the differences are. We're going to focus primarily on companies that are private equity-backed platform companies that are looking to grow rapidly through expansion, acquisition of smaller add-on or bolt-on companies.
And Josh, and here I think it's important to note that what we're about to talk about applies equally to strategic purchasers that are not necessarily private equity backed. So all of the concepts and notions here will be very transferable to those situations.
I think that's very true. And we'll call out as we go through this process where we think there are particular areas that are worth focusing on there. So when we talk about add-ons, the key differences is that they're smaller. They're usually an order of magnitude smaller than the platform transaction that set up the company to begin with. And what goes along with that is a feeling from the part of sponsors or management that full diligence on these much smaller entities is too expensive. You'll frequently hear it's an asset deal, it's a tiny deal. Similarly, these deals are often focused on for speed. Speed is key in getting these closed. There's pressure from finance arrangements or from the platform itself that it wants to grow at a certain pace. It wants to get acquisitions completed. It wants to reach a certain critical mass for either a liquidity event, potentially going public, doing something along those lines. So those pressures are always forcing the deals to move more quickly, and there's a concern that detailed regulatory diligence can slow down a deal. Focus on costs and doing things efficiently can mean a reluctance to get too many lawyers on the phone, and that's not entirely wrong issue. Sometimes paying by the hour faster can mean getting it done cheaper. So addressing these issues means really focusing in on the specific needs for the industry and the company that you're talking about and right-sizing your diligence. So when you talk about scope, the diligences that you're doing on an add-on versus a platform need to be much more focused on real genuine risks identified with regard to the particular industry that you're in. They need to focus on how this add-on transaction is going to change or affect the structure of the company. Frequently, I'm working with multi-jurisdictional companies that operate under a friendly PC or a captive PC model. You need to pay attention as to how you're integrating additional practices that are coming under a management structure, for instance. But that applies in a lot of circumstances. Licensure is an issue that's going to come up frequently, especially as David will talk about a little bit later on when you're looking at hospital transactions and similar transactions. Licensure issues will come up, and there'll be a key question in terms of moving forward with even a smaller transaction. Finally, when you talk about it, you want to look at your approach. You want to focus on having smaller teams and focused diligence, as we've discussed, and creating forms that are going to be effective to quickly move through risk allocation. And again, David will talk about that a little further on in our transaction, our discussion. Moving on to our next slide. So the real question I think to answer is why is health regulatory important even in smaller transactions? One key area is successor liability, and that comes up frequently in the context of provider numbers. But David, you and I were talking about before this how there can be other issues related to state law.
Right, and especially in asset transactions where typically an asset deal would be structured in order to keep liabilities behind at the seller level, but state law concepts of successor liability may nonetheless put the buyer on the hook for those liabilities, even though they were, at least by contract, kept at the seller or the target company. So just need to be very mindful of that.
And it's true, and the typical context where we're seeing this discussion from a health regulatory standpoint is with regard to provider numbers, right? Do we take the provider numbers? Do we leave the provider numbers? And that can affect whether you choose to go with an asset or an equity type transaction. In making that assessment, again, kind of looking at the company itself and what you're integrating it into is going to be key. You need to think about how important your AR is. Obviously, if you leave the provider number behind, you don't have any right to that AR. But ongoing financial issues are key as well. So how long will licensing or credentialing take if you leave provider numbers behind? And that can be a state-by-state question. Different states, especially in medical assistance and state Medicaid programs, they can take a very long time to get credentialed. So that can cause a cash flow crunch if you choose to go with an asset transaction and leave that number behind. If you keep the number, you really need to pay attention to diligence, because obviously you're carrying on the liability for any past bad billing acts or similar issues that that company may have had. Those issues don't necessarily completely go away if you do take a new number. So let's say you get a new number, you do with an asset transaction, but you've moved into the location, you're employing many of the licensed practitioners that were working in that location previously. And the state attorney generals who are looking at a company with regard to consumer protection, with regard to fraud issues, state boards that are looking at licensure issues, or other state entities that are looking at site license entities, site license requirements, corporate practice issues, fee splitting issues, they're not necessarily going to be convinced that you are a completely new entity just because you have a new provider number. So especially in circumstances where you're keeping much of the same personnel, and frequently that is exactly why you're doing the add-on, is to get the personnel or the location. You're not necessarily protected from past issues that that company had just because you're taking a new provider number. Similarly, any existing customer or patient issues that were lingering out there. So patient complaints, unhappy patients, customers who had filed complaints with state agencies, those are going to track the doctors involved or the professionals involved and the location more so than the provider number for reimbursement purposes. The big question that pops up and that diligence can be very helpful with is the question of whether or not to rebrand. Do you take this add-on and merge it into a large existing national or regional brand, or are you going to leave it as is and keep the kind of mom and pop identity that was in place? So questions to ask yourself and to look at through the diligence process is, if you choose to rebrand, and asset transactions typically follow this model, what are you losing in terms of your goodwill for the company? A lot of times the targets in add-ons are regionally famous brands. They're smaller and less sophisticated companies, but they're very popular in the area where they work. If you are the big company that comes in and takes over the much beloved smaller company and slaps your own identity over that, what kind of goodwill are you leaving on the table there? And the flip side of that is true as well. If you don't rebrand, what are the bad associations that you're walking into? How is this going to affect your future enterprise revenues with this add-on? Is the doctor or the professional staying involved, who everyone knows? Is the regional name essential to the success of that add-on? Is the regional doctor or the regional professional necessary to the success of that add-on? Those are all questions that you can look at during the diligence process from a regulatory standpoint, get a real sense of how the company works and how it's interacted with its customers and its patients and state regulators to understand whether it makes sense to keep that identity or trade it in. Cultural issues are a big question. Even if you are leaving behind a provider number and you're doing an asset transaction, if you are doing an add-on where you're planning to leave in place the professionals that are there and let the company just keep doing what it's been doing under new management, you're not answering the question of were they doing it correctly before. And if they had a bad culture before, if they were doing things wrong before or sloppy before, bad documentation before, they're going to keep doing it after. So when you leave behind that provider number, when you do that asset deal, you may think you're limiting your liability moving forward, but if they continue to do things incorrectly, that's going to create liability going forward that you may not even be aware of. Worth talking about liquidity events when we're asking whether or not to do diligence or to what degree to do diligence. Future buyers, investors, they're going to want to see and understand the diligence path that was taken. They'll want to see and understand deal protections, which David's going to talk a little bit about moving forward. They'll understand your decisions in terms of strategy for brand growth or keeping professionals around or replacing potentially problematic professionals. So all of these issues are going to form a diligence process that potential investors later will want to see. And so your diligence structures are going to have a direct impact on your price. You talked a little bit about the patient brand issues. Buying yourself a bad name can have a deleterious effect across an entire enterprise. Failing to look into those issues can be a serious mistake, even with a very small transaction. And finally, for unknown unknowns, or what I refer to those areas where with mom and pop style companies, smaller companies, less sophisticated companies, frequently they don't even know about the issues that they have. Subpoenas or other government touches get misdirected, misfiled, they're not followed up on. They have certainly been on deals where they've actively misrepresented their compliance status, or they've just hidden the ball in terms of government touches. And really just the absence of documentation, absence of sophistication at smaller companies can mean you really got to dig in, and you got to spend some time talking to them and getting to know them and kind of pressing them a little bit to make sure you understand the potential risks and liabilities associated with that company. In terms of talking about how best to go about that and where to really focus, I'll turn it over to my partner, Anjana.
Thanks, Josh. So on the next slide, there are some key areas that should be of focus regardless of whether it's a platform transaction or an add-on transaction for the reasons that Josh just identified. Number one, or high on the priority, is doing a billing and coding review. This is very important for various reasons. First, it goes to the integrity of the revenues. So it does, obviously affect bottom line and could have other ramifications in terms of purchase price and things like that. Secondly, this is an area of increasing scrutiny and enforcement by both the government and commercial payers, because a lot of these billing and coding red flags are low-hanging fruit for enforcement. And so it's important to get ahead and do the review. And then third, it's important to get the proper expert to help you do the billing and coding review, because you want them to do a focused review depending on the type of provider that the target is. And you want them to identify the common pitfalls for that particular type of provider. So whether it's a physician group or home health company, each will have its own sort of common red flags. But there'll also be certain red flags that apply across the board or the spectrum of all providers. For example, lack of adequate documentation to support medical necessity is frequently low-hanging fruit for enforcement and commercial payers. Overutilization compared to industry norms, certain cases upcoding or unbundling, billing incorrect modifiers, and more recently we're seeing review of the transition from ICD-9 to ICD-10 for certain types of providers. So the billing and coding review is really key, and it really should be undertaken. And then also consider that it should be done under attorney-client privilege, because sometimes if things are really bad and those are sort of identified as part of the billing and coding review, you want to make sure you're protecting the seller and the buyer from third-party litigation. Equally important is compliance with fraud and abuse laws. I mean, the Stark law, for example, is a strict liability law, so it's very easy to trip up against, and that could result in huge financial penalties and fines. And the kickback statute is both a civil and a criminal law, so that could have severe ramifications in terms of things like exclusion from participation in federal healthcare programs and even jail time. So the key question here is, you want to ask is, how does the target get their patients? What are their marketing practices? Are they paying or giving anything of value in exchange for referrals? You also want to look at their documentation. How are they setting compensation for referral sources? Do they have backup in terms of fair market value reports? And you want to kind of just understand their general compliance. How are they implementing certain structures to, for example, address whistleblower risk from, let's say, employees? So you want to get a handle on how they've historically handled that, and what they've identified and how they've addressed it or corrected it. Another area that is important for focusing on is reimbursement risk. So depending on the type of provider, each will have its sort of set of potential reimbursement risks. For example, in the dental space, pediatric Medicaid billing is an issue. And one way to sort of get ahead of that is to look at the OIG work plan, which comes out twice a year. And basically, it goes through the different types of providers, and the government kind of identifies the areas that they're looking at for each particular provider. Another area to focus on is compliance with the corporate practice of medicine or dentistry, which some states have. And a lot of add-ons are doing restructurings prior to recapitalizing with a PE sponsor or platform or a strategic buyer. So the question here is, have they done the restructuring correctly? And then lastly, of increasing importance is compliance with HIPAA, privacy and security, and really how is the data protected? Does the seller have cyber insurance to cover data breach? What other mechanisms are in place to mitigate the risk? So on the next slide, the issue is really how do you do this focused diligence in an efficient way? So one thing is, you have to think about assembling a focused, knowledgeable team of experts who really understand your goals, priorities, budgetary restrictions, and timing especially. So for example, if you are doing a billing and coding review, you want to hire a consultant who specializes in that particular provider type and who's going to be very familiar with the industry risks and red flags, because you don't want them to learn on your dime, obviously. Another thing is to have, very focused documentation and information requests. The key is to sort of compile a focused set of documents for that particular target provider. So think about doing a standardized due diligence list, which already kind of identifies the red flags for that particular type of provider. Think about doing a standard confidentiality agreement or a term sheet where, other than the economics, the provisions are sort of pro-friendly buyer, as well as a purchase agreement that is protective of the buyer. And then lastly, we've talked about this a little bit already, but think about, as a strategic decision, how to structure the transaction, whether it's going to be an asset purchase or a stock purchase. Obviously, there are competing considerations, including tax treatment for both buyers and the seller. But I'll let David talk a little bit more about that on the next slide.
Thanks, Anjana. So, just to pick up on that, asset deals, as I mentioned before, you have the liabilities that are identified, and usually only certain liabilities are assumed by the buyer, with the bulk of them presumably left over at the target company or the seller. By contrast, in a stock deal or in a merger, generally all the liabilities of the target company will become those liabilities of the buyer. So what is the primary mechanism to protect buyers from any of these unwanted liabilities? And the answer is indemnification. This applies in both stock deals, mergers, and asset deals. It's a provision in these purchase agreements that protects not just against the liability itself, but it also covers attorney's fees and other costs of defense. So it's a very powerful protection. In the context of add-on acquisitions, this presents somewhat unique issues regarding indemnity protection. So typically, the owner of the target company is expected in an add-on acquisition to sign on with the buyer and leverage his or her knowledge of the business and the relationships that he or she has with the target company's customers, patients, suppliers, and employees in order to drive the success of the buyer of the business post-closing. So if an indemnity claim arises, it's likely going to have to be at that former owner's expense, at least in part. So the challenge is to be able to get protection on the buy side without alienating the former seller, who will end up being on the hook for all or part of the indemnity claim. So we have a few tools that will enable us to achieve this somewhat delicate balance. And the tools aren't necessarily unique to add-on deals, but they have greater importance in an add-on deal, the way you manage it. So, for example, I'm sure folks have heard of escrows and holdbacks. These are two primary tools, and just to describe them, escrows are typically funds that are set aside at closing and are held by a financial institution in case an indemnity claim arises. By contrast, holdbacks are funds that are set aside but held by the buyer, and they're never funded at closing. Of course, buyers prefer holdbacks. But the key here, in the context of these add-on acquisitions where you've got former owners who are part of the buyer going, or part of the company going forward, is that these funds are held by other parties and not the seller. And therefore, the pain of an indemnity claim is perhaps less felt or less severe if it should arise, because as a practical matter, sellers, or frankly anyone, no one wants to ever have to write a check. And having the funds come out of a separate set-aside would basically obviate that bit of pain. Another set of tools that we have are what's known as baskets and caps. Baskets are otherwise known as deductibles. Those serve to protect the seller against claims by basically ignoring the small stuff. So in the case of a basket or a deductible, only those claims that are in excess of that amount are subject to indemnification. Sometimes in some deals, once that basket or threshold is met, the indemnity goes back to the first dollar of damages. But the idea here, again, is not to make the seller on the hook from the first claim that comes in the door. There has to be it has to be of sufficient size or sufficient number of claims before the seller would be on the hook. And there's actually another related concept that you may have heard of, which is a de minimis basket. And that's truly to allow folks not to sweat the small stuff. So typically here, that could be as little or as much as, depending upon the size of the deal, $1,000 or $5,000 or even $25,000, such that if a claim comes up of that small amount, no one wants to spend the time and energy and money, frankly, to get attorneys involved to argue over what's ultimately a very small amount. And again, this allows the seller, who's now part of the buyer, to focus on the business and to drive success at the business level. And then I mentioned caps. Those are mechanisms in place that would allow a seller to cap their total liability in the event an indemnity claim arises. Sometimes they are as high as 100% of the purchase price, but they could be often at only 10% of the purchase price, and sometimes even less than 10%. So again, this gives the seller some peace of mind that he or she won't basically lose his or her entire deal upside and allow to focus on the success of the business post-closing. There's also lately, and when I mean lately, over the last several years, the notion of representation and warranty insurance, which is a newish mechanism that allows that's usually procured by the buyer, and this is possibly the most robust protection a seller could have, because if an indemnity claim arises and there's rep and warranty insurance, that insurance company will pay the claim. Here, of course, the seller would never have to go out of pocket, and allow the seller to really just walk away and focus on driving the success of the business at the buyer side. It takes the seller out of the picture altogether. And one other concept, before I turn it back to Anjana and Josh.
Actually, can I add to your comment on reps and warranty insurance? I think it's important for buyers to realize that it's not a substitute for diligence. A lot of times the insurance company is going to want to piggyback off the buyer's due diligence in order to issue the policy. So to the extent the buyer could have discovered known liabilities, they won't insure the known liabilities. Let me give you an example. For recently, we were, as part of a transaction, the seller had a Stark violation. So that came out in diligence. So that is a known liability. So the rep and warranty carrier will not insure that.
That's a great point. So there are some limitations, and it's not a substitute for diligence.
Exactly.
Yeah.
Well, I just want to chime in very quickly to let folks know, to the extent you have questions as Anjana and I are finishing up here a little bit, please go ahead and put those in. We'll be turning to those after the presentation, but if they come in and we want to turn to them during, we may very well do that. So, Anjana,
Josh, that actually takes us to the next slide.
Yeah, and actually, there are also other ways to mitigate risks. You know, in addition to the protections you mentioned, David, and we could negotiate in the actual purchase agreement or getting reps and warranty insurance if that's available. One other way, for example, is getting certain types of backup reports, like a fair market value report or commercial reasonableness report. And usually this, you know, if you get it from a reputable healthcare consultant who is familiar with that type of provider, you know, can alleviate a lot of concerns, especially around the Stark and kickback laws with respect to how referral sources are paid. If you get these reports, you know, you kind of have a little bit of insurance that you can rely on. Another sort of strategy in terms of mitigating identified risks is think about, especially in the fraud and abuse context, self-disclosures. You know, there are different protocols, which, Josh, you can chime in on, that might be another way to mitigate the risk.
Yeah, the protocols that are out there for Stark, OIG, CMS for Stark, OIG, Department of Justice, there are various private insurers that have protocols for going through repayment. And there are rules that apply that really were not a part of this discussion, but in terms of requirements to make repayments or requirements to identify overpayments that have been made to a provider have gotten stricter over the years and carry very significant penalties for those involved. That goes back to Anjana's point earlier about ensuring that when you retain consultants and others to do billing and coding audits, you retain them through attorneys and maintain privilege. But it also brings up the issue of who should do a disclosure in the event that an issue is discovered. And I've worked on situations where it's been handled both ways. Both, you know, you need to handle a disclosure here, seller, and you need to get this release from the government and get confirmation that this issue has been resolved before closing. I've also worked on ones where it was a known issue for the buyer, and then immediately post-closing, they looked towards fixing those issues. The key point in both of those, I think, is to make sure that the buyer maintains control of the process so that the buyer can ensure that it's handled properly and the issue is actually resolved. And finally, I just want to note that it's important to think about, and it can be a hard thing to talk about, but to know when to walk away. And sometimes when you're dealing, especially with smaller, less sophisticated companies, there just comes a point when the risk levels are getting very difficult to get your arms around. And at that point, it may be time to really seriously consider the value that this potential add-on is going to have versus the liabilities that it may smuggle into your organization in a very small package. And I think that's the end of our presentation, and we can open the floor to some questions.
Josh?
Yes.
Yeah, there's a question that we're getting about a little bit more on reps and warranty insurance, and you know, what are we seeing in terms of market regarding like things like deductibles and premiums that apply there. So let me answer that by saying that we typically see deductibles for policies here range in the from 1% to 2% of the enterprise value. And we also, with respect to premiums, those are usually around 3% to 4%. So these limits are not hard and fast, but that's where we're seeing market these days.
Yeah, and keep in mind that this is going to change. The whole reps and warranty insurance, like you said, David, you know, it's sort of relatively caught on in recent years. And so what it looked like 3 years ago, 5 years ago is very different from what it looks like today and where it's going to potentially end up going in the future. So.
Actually, and where it seems to be going is that it seems to be expanding. So in the old days, you'd see rep and warranty insurance only for the largest of transactions. And these days, we're seeing them for deals that have an enterprise value in like the $25 million or $20 million range. And I think that the more and more that these policies get respected and people are more and more comfortable with them, that these will just continue in even smaller transactions. So, and as Anjana said before, although they're no substitute for due diligence, they certainly can, have benefits that are not just financial, but in terms of protecting a buyer, but also will allow a buyer or a seller, I should say, to focus on the buyer's business going forward.
Right, and that's actually a good point. The fact that you have reps and warranty insurance probably kind of takes away that tension between a buyer and a seller who then becomes an employee or even co-owner in the going forward enterprise. So it kind of eases some of that tension.
Exactly.
And that raises a valuable point about who's responsible to pay for the rep and warranty insurance as well. And I think that's always something to consider with the deals when you're looking at situations where you're going to have an ongoing relationship with the professional. I mean, this may be an issue that impacts price in a sense where if they're unwilling to look at more traditional indemnifications, saying, well, we'll look at rep and warranty and that may be able to help us here, but you need to share the pain a little bit. And that can be effective, especially when it's brought into the conversation near the end of negotiations when a potential seller is already sort of fixated on getting the deal closed.
That's a good point. Okay, I see no more questions. David, do you want to wrap up?
This concludes today's webinar. A reminder that in 2 to 3 business days, Epstein Becker Green will email registrants a link to access a recording of the presentation and PowerPoint materials. We hope you'll join us for the next installment of this series, which is scheduled for next Tuesday, October 16th at 12 p.m. Eastern Standard Time. Presenters will discuss different approaches to proactive employment law compliance initiatives for platform companies to implement as they continue existing operations and expand operations via integrating new acquisitions. For more information and to register, please visit www.ebglaw.com/events. Thank you for attending.